Good evening, ladies and gentlemen. I'm going to call the public hearing for March 21st, 2022 to order. And I do have an opening statement because we do have people who are possibly going to present. The council meeting is being convened in order to hold public hearings on land use matters. The hearing, the public and anyone who believes that their interest in property is affected may speak or present written submissions to council. Everyone will be given a reasonable opportunity to be heard. No one should feel discouraged from making their views known. Those of you who wish to speak or are registered with the city clerk should, after being recognized by the chair, begin by clearly stating your name and your address. If you have provided a written submission, please make this known at the beginning of your presentation. All written submissions will be retained by the city clerk and will form part of the record of the hearing. Each speaker may address the hearing a maximum of twice. Your first presentation will be limited to a maximum of 10 minutes. Your comments must be relevant and not obstruct the hearing. Any additional presentation, which must be on new information, will be limited to 3 minutes. Members of council may ask questions of you following your presentation. However, the function of council members during a public hearing is to listen to the views of the public, not to debate the merits of the matters with citizens. Any debate by members of council will occur at the subsequent vote. The order of proceedings for each item will normally be as follows. Firstly, the city clerk will briefly describe the matter under consideration. Then the applicant or their agent will be invited to make a brief presentation of up to 10 minutes. Then the city clerk will identify any written submissions received. Then oral submissions from the public will be heard and any further written submissions will be received. And finally, the hearing will be closed and matters may be considered. Please observe these rules. If you have any concerns with the manner in which the hearing is conducted, please direct your comments to the chair. So, Madam Clerk, first item.
Thank you, Your Worship. Item 1 is Richmond Zoning Amendment Bylaw 10077. The location is citywide. The applicant is the City of Richmond, and the purpose is to amend the Richmond zoning bylaw to increase the implementation of transportation demand management measures and reduce the requirement for large-size loading bays on residential sites. First reading was on February 28th.
Okay, so the City of Richmond is the applicant. Mr. Craig or any member of staff, is there anything you want to mention here?
Your Worship, I have nothing to mention. We're ready to go.
Okay. Just a minute. Is there any written submissions?
None, Your Worship.
Okay, so you moved second and third and seconded. Any discussion? All those in favor, post carried.
Move adoption.
Moved and seconded. Any discussion? All those in favor, post carried. Next item, Madam Clerk.
Item 2, Richmond Zoning Amendment Bylaw 10288 for the location of 6571 and 6591 Number 1 Road. The applicant is 053803 BC Limited and 1121648 BC Limited. And the purpose is to rezone the subject property from single detached RS1F to the low-density townhouses, RTL4, to permit the development of 8 townhouse units with access from Number 1 Road. First reading was on February 28th.
All right. Now, there are people here on this one. First of all, there's Ajit Thaliwal.
Yes.
Did you wish to make a presentation?
I'll wait for questions.
Okay. And Raman Kuner, same.
Yes, sir.
But also we have Eric Law. If you want to turn on your mic and your video, Mr. Law, is there anything you want to add or do you just want to await questions?
No, I don't have anything.
All right. Now, Councillor Day, you have a question of some sort? Okay, well, why don't we ask that of Mr. Law? Go ahead.
Okay. Hello, Mr. Law. Thank you very much for being here.
Hi.
I have a letter in front of me from Mr. Shiraz Mohammed. He lives at 6551 Number 1 Road, so directly beside your property. He has lodged strong opposition to the rezoning repeatedly, and he says in his letter, that's on our page 33, that they were bullied into taking a below market value offer for their home. Do you have anything to say to that?
No, I think from what I understand is the client has been approaching for several times already, and I think there are already records from the client that they offer to the adjacent property for a lot of times, and also sent record to the city already for a fair market price for them to purchase the lot for try to incorporate into this development. Perhaps the owner will, if you want more details, I think the owner is in the city hall right now, that he may can give you more details on that.
Yeah, I have some major concerns over this because I understand he was offered 1.6 million on October 21st. And, well, we all know how much real estate has gone up. And I'm wondering if you'd be willing to work with this owner again to see if you can't resolve some of these issues. Because if this development gets built, he'll be sandwiched in between two townhouse complexes. And that could be problematic for him selling down the road.
Maybe we could ask Mr. Law, has any arrangement been made should Mr. and Mrs. Mohammed's property eventually be redeveloped, whether there's any coordination with your complex, with this complex?
Yeah, actually, yes, we work with the city staff on our property. We are providing access for them through our property. There is an access road share to them so that they don't need to do their own access road. They can, if they want to develop, then they can access through our site with an access road to them. And that's actually is more efficient to them if they want to develop their site. And in fact, they can, I believe they can develop up to 4 or 5 units on their site. But compared with our site, which we only allow only 8 units, but our site is double the size of their site. So basically, if they want to develop their site, they have more efficient space. And in fact, in addition to that, we allow for a shared garbage room that they can use in our site so that they don't need to provide those facilities within their site. We have provided some, therefore, we provide some of the provision for them already on their development.
All right, Councillor McPhail.
Thank you, Your Worship. My question is of the applicant as well. This Mr. Mohammed is also concerned about drainage. So just wondering, I mean, I know there's, building code and everything to follow. So what are you going to do on your site to ensure that, the drainage is done properly?
I believe you're talking about the site drainage of that site. Basically, what we are doing is that we maintain the same grade. The road will be maintaining the same grade as with the site, so that we don't have any water going to their site. It's all within our site, and within our site, there's always a building code requirement that we have to provide perimeter drainage that our water won't be able to get into their site, so it won't affect them.
Thank you. And then, Your Worship, just through to staff. So the applicant was already talking about that he has, confirmed that Mr. Mohammed will have the right of way to use the driveway and everything, and that's really great. But through you to staff, has this been confirmed then with Mr. Mohammed? He's aware of this? Because we have correspondence from March 18th asking for this. So just want to make sure that he's aware of everything, and that'll be on title for him and everything like that. Is that correct?
Yes, through your worship to Councillor McPhail, that has been communicated to the applicant that the access to the proposed application's driveway would be secured through an SRW for that purpose. So that has been confirmed.
Great, thanks very much.
Yeah, you'll see that those kind of conditions are included in the rezoning considerations that are on page 45 and on.
Thank you.
Councillor McNulty.
Yeah, thank you. That was the one thing I was going to ask. That I'm surprised at the letter on 33. I think somebody better read between the lines. This development will actually enhance his property no end and make it probably more valuable than the other 2 lots. So he is getting a right of way if he wishes it through there, so it's not going to hurt him whatsoever. And I'm not going to get into whether values go up or down. That is not our prerogative here at it. And I understand from Mr. Law that he's going to get 4 or possibly 5 potential townhomes on his property, and you only, with 2 lots, get 8?
Yes, yes.
Okay, thank you. Okay, Your Worship, thank you.
All right, Councillor Hobbs.
Thank you through the chair. Actually, Councillor McNulty just clarified that. I think the road access is what I was going to ask about, and that is quite an advantage actually for the neighbor.
Okey doke. Madam Clerk, any written submissions besides the ones we've gotten?
No, Your Worship.
All right. Okay. Move second and third. It's moved and seconded. Councillor Day.
Staff regarding the drainage. Everyone has had this experience in a neighborhood where 2 new houses get built and the house in the middle ends up being the swimming pool for the neighborhood. Is it possible for the water problems that are in the letter that we received tonight from Mr. Mohammed, no matter what they do in the townhouse complexes, to actually mitigate this problem? Or would it be necessary for a drainage area to be built in the back of Mr. Mohammed's property in order to prevent this pooling of water?
Through your worship to Councillor Day, my suspicion would be that the property to the north does not currently have any perimeter drainage installed on it based at the time in which it was developed. The applicant is quite right in indicating that they will be required to install perimeter drainage on their property. They are also not raising the grade of their property, so there would not be any change in grade between this property and the property to the south. In terms of the pictures referenced in the letter attached, our retaining wall in that picture is actually for the adjacent townhouses, which are already constructed to the west, which are substantially higher than the subject site or the author's site.
Mr. Craig, you're confident that this development will not make it worse. It might not get any better, but it won't make it worse.
Through your worship, that is correct.
Thank you.
All right, we'll call the question then. All those in favor? Any opposed? That is carried. And then next item, Madam Clerk.
Thank you, Your Worship. It's item 3, and there are 15 Richmond zoning amendment bylaws, as noted on the agenda on page 2, for the location of 20 properties located in the Blundell, Seafair, Steeston areas and the north portion of City Centre that are specifically noted on the agenda. The applicant is the City of Richmond, and the purpose of this application is to establish underlying zoning for 20 properties developed under land use contracts 004, 005, 024, 026, 028, 029, 045, 047, 056, 070, 075, 087, 092, 122, 126, and 128, located in the Blundell, Seafair, Steeston areas and the north portion of City Centre. The existing land use contracts will remain effective and will continue to govern the use and development of the affected properties until their termination date of June 30th, 2024. First reading was on February 28th.
All right, so this is a city application to staff. Is there anything to add? I think we're familiar how this is the last chapter of a long saga.
Nothing to add, your worship. Happy to answer any questions.
All right. Any written submissions, Madam Clerk?
None, Your Worship.
All right. No, just a minute. Councillor Day has a question.
I understand, looking at the PH 57 in our binder, that there are 582 residential units and that these would be maintained. But if a redevelopment proposal came forward, that they could increase the density of those residential units. Is that correct?
Through your worship, the future use of these properties would be governed by the official community plan. Through rezoning applications that are consistent with the official community plan, there may be potential to densify those properties.
All right, thank you very much.
All right, let's see, nobody's here to talk about this, so. Move second and third. Discussion, all those in favor, opposed, carried, and the adoption. Moved and seconded. Any further discussion? All those in favor, opposed, carried. Madam Clerk, the next item.
Item 4, Official Community Plan Amendment Bylaw 10328. The location is citywide. The applicant is the City of Richmond, and the purpose is to include accelerated greenhouse gas emission reduction targets for 2030 and 2050, consistent with limiting global average temperature rise to no more than 1.5 degrees Celsius by year 2100. First reading was on February 14th.
All right, from staff, is there anything to add to the reports and the previous discussions? I'm not seeing, Norm, anything to add?
Your Worship, staff have nothing further to add and are available to answer any questions on the proposed amendment.
All right.
Yep.
Any written submissions?
None, Your Worship.
And nobody's here to talk about it, so moved and seconded. All those in favor? Any opposed? That's carried. And adoption? Moved and seconded. All those in favor? Any opposed? That's carried. Next item, Madam Clerk.
The next is item 5, Official Community Plan Amendment Bylaw 10339. The location is citywide. The applicant is the City of Richmond, and the purpose is to provide updated tree protection requirements. First reading was on February 14th.
Okay, another City of Richmond application to staff. Is there anything to add? Gordon Jaggs or anyone else? Mr. Cooper?
Your Worship, there's just a point of clarification. The reference is amendments to the Official Community Plan Bylaw 9000 and 7100 Amendment Bylaw 10339 is to make into alignment the OCP requirement for plantings with the changes to the tree protection bylaw that was passed.
All right. All right, Councillor Day.
Thank you very much. Well, I couldn't be more excited about these changes that are going to save some significant trees that are 36 inches in diameter or better. I think staff have done a really good job of making sure that if a tree is unlawfully removed, that the new trees have to come in at a 3-to-1 ratio and they have to be 8 meters high in the same location. So there's no longer an advantage for developers to come in and level the trees and think they can get away with it. But I am confused about one little thing. On page PH 374, it states that they can compel the property owner to remove a hazardous and/or standing, dead, or dying tree. Sometimes a dead or dying tree is a great habitat for birds and whatnot. So is there flexibility the way this is written, or do we need to add the word if hazardous?
Okay. Through your worship to Councillor Day, I think it's a natural progression. If we find that a tree has been done, wantonly destroyed, we need to have something to compel the property owner to remove the tree in order to replant a sizable tree, a significant specimen, within the same location. So the answer to your question is yes, of course. This is the tool we need in order to replant a really big tree. So, and if a tree dies of natural causes and it is not a hazard and is providing a biosanctuary or biohabitat, then of course we would not compel anyone to remove it.
Well done. Thank you for this. This is a really, really important piece of bylaw. Thank you.
All right, any written submissions?
No, Your Worship.
All right, and nobody's here, so action on second and third. Moved and seconded. Any discussion? All those in favor, opposed, carried. And adoption? Adoption. Moved and seconded. All those in favor, any opposed, that is carried. And item 6.
Item 6, Official Community Plan Amendment Bylaw 10344. The location of the Steeston Area Plan. The applicant is the City of Richmond, and the purpose is to amend public access policies to and along the waterfront contained in Steeston Area Plan, Section 2.4. First reading was on February 14th.
All right, another City of Richmond application. Is there anything that staff wants to say about this? I think we went through it at the previous hearings.
To your worship, nothing further to add.
All right, and no written submissions?
No,
Okay.
that's correct.
Councillor McNulty, you had a point?
If I can, to staff, at Planning Committee, I brought up a concern about having housing along the Bayview on a particular lot. What does this do to that particular referral that you got on it?
Through your worship to Councillor McNulty, this report does not address that referral. That referral will be dealt separately in a report that we're intending to bring to council in April/May of this year. So that's forthcoming.
But
so this report or bylaw, this report and bylaw just deals with public access to the waterfront only.
So it doesn't talk about development at all when we do it?
That will be the next report and bylaw coming forward.
Okay, it's just, okay, all right, thank you.
Stand by on that one.
Yeah, well, definitely stand by on that one.
Yeah. Councillor Day.
Thank you very much, Mayor Brody. My question is regarding, there's a map on page 415, and the property that I'm concerned with is 3866 Bayview. And currently there is a restaurant there, and the restaurant has expanded out to the railing of the dock. And according to your page 410, it states that prior authorizations for the use and development have been granted by the province of BC. And I'm just curious why that is, because if that restaurant did not go to the end of that railing, there would be better public access around that 3866 Bayview. Do staff have any updates on that?
Through your worship to Councillor Day, that is also part of the referral that was just brought up a moment ago, where we'll be looking at sort of the history of that property and what was promised and what didn't happen or what did happen. So we will be bringing that forward within a month to council.
So just to clarify, the province has jurisdiction over that, the walkway that's built?
There's an outstanding referral. You're going to find answers to your questions when we get it back.
Okay, I think those are much needed. Thank you very much, Mayor Brody.
All right, action on second and third. Moved and seconded. Any discussion? All those in favor, opposed, carried, and adoption. Moved and seconded. All those in favor, opposed, carried. And the final item, temporary commercial use permit.
Thank you, Your Worship. This is item 7, and this is for the location of 140-11300 number 5 Road. The applicant is Foursquare Gospel Church of Canada. The purpose is to issue a temporary commercial use permit for Unit 140 at the address to allow religious assembly as a permitted use for 3 years from the date of issuance. First reading was on February 14th.
All right, the applicant is not here. Any written submissions?
Your Worship, just to clarify, Mr. Kevin Preston is the applicant and he's in the meeting.
I'm sorry, I overlooked that. Yes, you're absolutely correct. So, Mr. Kevin Preston, you're here with the meeting. Did you wish to make a presentation or just await some questions?
I will answer any questions, but I do have an opening statement, I would say. It'll be very brief.
Yeah, let us have your thoughts.
All right. I just want to let you know that Richmond Christian has been part of the Richmond community for close to 40 years. Me personally, I only work at the church as their pastor part-time. I'm a project manager at Suncrest Cabinet in Richmond. And 5 years ago, I took over the pastoring of this church. And we purchased this property back in 2004, and our lawyers at that time sent a letter to the city of Richmond stating the fact that we would be using the property for a religious assembly. However, we have not done that. We've rented other facilities, high schools, etc. But around 7 years ago, we could not afford to rent McNeil Secondary anymore. So basically, the church, prior to me coming on, moved back to what we called the ministry center, where our offices were. And at the back of the facility is a warehouse, and that's where they set up, where we would have around 20 people. Our intention was never to stay there. Our intention was always to move out, find another location for our church, keep that facility as our office, but find another area for our worship, where it's just basically Bible studies, ladies' teas, different things like that. And around 2 years ago, well, first of all, 5 years ago, I did meet with the at City Hall and talk to the bylaw people, and they said, yeah, there wouldn't be any problem for us to have such a small meeting, that they would keep it under the covering of a school, like a Bible school. And then 2 years ago, we were given notice that we were illegally having services in this location, and we're told that we would have our location locked and we would be fined. I made contact with a gentleman, Joshua Reese, from the City Hall, and a very good meeting with him, and he suggested that we apply for a temporary use permit. So that's what we are doing. Our intention is to stay there as far as our offices go, but we are looking to go. We've actually sought counsel from other real estate agents and such. So we would like the temporary use permit to allow us the time to be able to find another location.
Very well, thank you. So, let's see now, you said no written submissions?
That is correct.
Okay, and,
The permit be issued for 3 years.
okay, so that's moved to issue and seconded. Any discussion on that? Okay, we'll call the question. All those in favor? Any opposed? That is carried. Thank you. And we are now adjourned. Thank you. Thank you, Mr. Preston.